So, have you ever actually just stopped for a second and looked at the opening words of the U.S. Constitution?
Like, really looked at them, yeah.
Yeah, exactly. Just, those three famous words right at the top. We the people.
Right.
And, I mean, have you ever wondered why it doesn't say we the citizens?
Which is such a good question, honestly.
It really is. And according to this massive stack of materials we have for today, that specific word choice is not just some stylistic thing by a bunch of guys in powdered wigs.
No, not at all.
Like, it is literally the difference between being the master of the country or being its servant. So, welcome to the deep dive.
And, before we really get into the mechanics of how those two words supposedly create entirely different legal realities, we should probably set some parameters for what we're actually doing today.
Right, because the source materials we are pulling from, and it's a lot of stuff, like a sprawling collection of older legal lectures, definitions from vintage editions of Black's Law Dictionary, specific Supreme Court rulings, and this incredibly dense U.S. Senate document. They build a legal framework that is, well, it's highly unorthodox.
Highly. That's a good word for it.
Yeah, it touches on intensely charged constitutional arguments regarding sovereignty, the nature of the state, and just the whole foundational system of American law.
It really gets into the weeds of political and legal theory.
It does. So, to you listening, I want to be entirely unequivocally clear about this right up front. We are not endorsing this framework.
Right. We aren't advocating for it at all.
We aren't validating it, and we're absolutely not taking sides on whether this is how the legal system actually operates today. Left wing, right wing, whatever. We are not taking a stance.
Exactly. Our sole mission today is just to neutrally construct the argument exactly as it exists in these texts.
We are just holding this theory up to the light to examine its architecture, not to sell you the house.
And that neutrality is so critical here because the architecture of this theory is, it's staggering in its implications.
It really is.
The central thesis we are examining argues that Americans have been linguistically and legally maneuvered into abandoning this innate sovereign status in exchange for a deeply subordinate role.
And it all starts with those three words, we the people.
Right.
The sources argue that within the American legal framework, people and citizen are just not synonyms.
They are not the same thing.
Which is wild because, in everyday life, they're just two ways of describing a guy walking down the street in Ohio.
Sure, colloquially, yes.
But legally, according to these texts, they are two entirely distinct classes of humans, governed by two completely different sets of rules.
Yeah, so to really understand the distinction, the texts start with the origin point of the framework, which is the preamble of the Constitution. And the phrasing is highly, highly specific. It states, we the people do ordain and establish this Constitution for the United States of America.
Okay.
So the legal theory hinges entirely on the relationship dynamic that single sentence creates.
The dynamic of creator and creation.
Precisely.
Because if we the people are the ones doing the ordaining and the establishing, they are the architects. They literally drew the blueprint.
Yes. And a foundational concept in the legal philosophy cited in these lectures is that the creator is always inherently superior to the creation.
Right, like a wooden chair cannot dictate terms to the carpenter who built it.
Exactly, that's the perfect analogy. Therefore, the people are inherently sovereign relative to the government they created.
Okay, I follow that.
So the logic flows like this. The people existed before the Constitution. They already possessed absolute inherent natural rights.
They didn't need a document to grant them freedom?
No, not at all. They authored a document to create an agent, the government, to perform very specific, limited administrative tasks on their behalf.
So if you identify as one of the people, you are standing firmly above the government. The government is like your employee.
That is the argument, yes.
But then the framework introduces the second category, right? The citizen. And I look at this and think, well, aren't the people just a group of citizens?
That's what most people think, yeah.
But the source material draws a really hard line at the 14th Amendment, which was ratified in 1868, as the true birth of the citizen class.
The 14th Amendment provides the legal definition they are focusing on.
Right.
The text reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States.
Let me just jump in here for a second, because when most of us hear that, we completely stop listening after the first 6 words.
Oh, absolutely. Born or naturalized in the United States.
Yeah. Like, I was born in a hospital in Chicago, therefore I am a citizen. Boom. That's the standard understanding we all have.
But the sources are hyper-focused on the comma and the clause that follows it.
Right, that and subject to the jurisdiction thereof part.
Exactly. It's treated in these texts as a conditional clause. It's not just a description of where you are, it's a requirement.
Wait, a requirement?
According to the textual analysis in our sources, it is an absolute dual requirement. To be a citizen, under this specific constitutional definition, you must meet condition A.
Which is being born or naturalized.
Right. And you must also meet condition B, which is being subject to the jurisdiction.
And subject to the jurisdiction just sounds like typical legal jargon. You know, just lawyer speak.
It does, but the sources actually break down the etymology and the strict legal meaning of being a subject.
Right, and what does it actually mean in that context?
In historical legal terms, to be subject literally means to have a master.
Oh, wow.
Yeah. It implies a state of subordination and obedience to a sovereign power.
So you are beneath someone else.
Exactly. Therefore, under this theory, the government is the creator of the citizen classification. The government defines what a citizen is, grants the status, and dictates the terms of that status.
Which completely inverts the power dynamic we literally just talked about.
It completely flips it on its head.
Because if the people created the government, the people are the masters.
Right.
But if the government created the legal category of citizen through the 14th Amendment, then the citizen is the creation.
Yes.
The citizen is subordinate to the government.
One of the lectures in the sources summarizes it quite bluntly, actually. They say a citizen in this framework is a publicly owned subject of the state.
A publicly owned subject of the state.
Mm.
That is just a massive paradigm shift.
It really changes how you view everything.
I mean, if you are one of the people, you operate above the government with natural inherent rights.
Yes.
But if you identify legally as a citizen, you are effectively trading those inherent rights for, like, conditional privileges granted to you by your creator, the government.
And that mechanical difference between a natural right and a civil privilege is absolutely central here.
Break that down for me.
Okay, so a natural right, according to this theory, is absolute. It cannot be regulated, it cannot be licensed, and it cannot be revoked by a government simply because the government didn't grant it in the first place.
Because you had it before the government even existed.
Exactly. A civil privilege, however, is basically an allowance.
Like getting an allowance from your parents.
Right. It is a benefit granted by a superior to a subordinate, which means the superior retains the absolute authority to regulate it, tax it, alter it, or just take it away entirely whenever they want.
Man. Which brings us to this grammatical argument in the text that honestly just broke my brain for a minute.
Oh, the singular noun argument.
Yes, the analysis of the word people. Because in modern English, we exclusively use people as a plural noun.
Right, a crowd of people, a room full of people.
Exactly. But the sources dig into these much older dictionaries and legal texts to argue that people can actually be used as a singular noun.
And it feels so grammatically wrong to modern ears, right? To say, I'm a people.
It sounds totally absurdly. I failed first grade grammar.
It really does.
But the texts lean heavily on Webster's 1828 dictionary to validate this. And they point out something I had literally never considered before.
What's that?
The actual correct grammatical plural of the word person is persons, with an S at the end. It is not people.
Right. And the 1828 Webster's Dictionary defines people primarily as the body of persons composing a community or nation.
Right, the collective.
But it explicitly notes that the term can be applied to any portion of the inhabitants.
Any portion, meaning down to one.
Exactly. The lecturers use this to build a legal mechanism where, theoretically, a single individual can claim the status of a people.
So you don't need to gather a giant mob to be the sovereign creator. You, just as a solo individual, hold the sovereign status of a people.
Right, because sovereignty, at least in this context, isn't some collective trait that you only get when a bunch of you are in a room.
It's not a team sport.
No, it is an individual inheritance. By claiming to be a singular people, you retain the sovereign power that established the government in the first place.
But practically speaking, I mean, how does that even work with birthright citizenship?
What do you mean?
Because if I am born in the U.S., which fulfills the first half of the 14th Amendment, doesn't the government just automatically assume I am subject to their jurisdiction?
That is how it plays out in practice, yes.
So do I have to actively opt out of that, or is the source saying I actually have to consciously opt in to become a citizen?
Well, the theory posits that jurisdiction is not a geographic inevitability.
Okay.
It is a consensual legal state. The argument is that you can absolutely be born geographically in the United States, satisfying condition A,
Right.
but choose not to subject yourself to the jurisdiction, thereby failing condition B.
Meaning you never legally become a 14th Amendment citizen at all.
Correct. Under this interpretation, if you do not subject yourself to the jurisdiction, you remain outside the government's direct statutory control.
You just exist outside of it.
You retain your original innate status as a sovereign people. The government only possesses general authority over its own creations, its citizens.
Because it made them.
Right. It does not possess general authority over the sovereign people who created it.
Unless a sovereign person specifically consents to a contract, or, I guess, injures someone else.
Exactly.
It honestly reminds me of someone walking into a massive corporate headquarters that they secretly founded and own. But the security guard and the floor managers all just assume they're a new hire who needs to be told what to do.
That dynamic of hidden ownership is actually a perfect segue into how these sources re-examine the actual structure of the American government.
Oh, the republic versus democracy thing.
Yes. They argue that this confusion between being a sovereign people and a subject citizen is why modern political discourse completely fails to understand the difference between a republic and a democracy.
Which is funny because we use those words as synonyms every single day on the news.
Constantly.
But the sources treat them as fundamentally opposing forces. And, it made me think of being a kid in school, standing up every morning, putting my hand over my heart.
Doing the pledge.
Yeah, and saying, I pledge allegiance to the flag of the United States of America and to the republic for which it stands.
Right.
We never pledged allegiance to a democracy.
We didn't. And the texts draw a rigid, absolutely uncompromising line between the two systems.
Okay.
And they do acknowledge that mechanically, from the outside, they look virtually identical.
Sure, and they both have voting.
Both have elections, both have voting, both have representatives debating in chambers.
But the foundation of where the power actually sits, where the sovereignty is located, is entirely different.
They're
Right?
completely different.
So when I look at this democracy versus republic breakdown in the text, it's really messing with my head. The sources are strictly defining a democracy as purely majority rule.
Yes.
Like where 51% can literally just vote away the rights of the 49%. Is that really the structural argument they're making?
It is the absolute core of their argument regarding democracy. In a democracy, sovereignty resides exclusively in the group.
The collective.
The collective body politic is the supreme authority. 51 beats 49 is just the mathematical law of the land.
Period.
Because the group is the sovereign, every individual is subordinate to the group.
So whatever the majority decides becomes mandatory law for absolutely everyone, no matter what.
Mandatory and inescapable. The sources are incredibly blunt about the mechanical consequences of this structure.
What do they say?
They say that in a pure democracy, the minority has absolutely no rights.
None.
None. They only possess privileges that the majority graciously allows them to temporarily keep.
Wow.
So if 51% of the population votes to seize the property of the other 49% or silence their speech, it just happens. And within the mechanics of a democracy, it is an entirely legal and valid action.
It's that classic analogy that one of the texts brings up, that a democracy is basically two wolves and a sheep taking a vote on what's for dinner.
Yes, exactly.
The majority wins, but the sheep gets eaten perfectly legally.
The analogy perfectly illustrates the inherent danger of collective sovereignty overriding individual existence.
It's terrifying when you phrase it like that.
But then they contrast this terrifying mechanic with the structure of a republic.
Right, where the mechanics of voting and debating are the same, but the sovereignty isn't held by the group.
Right.
In a republic, sovereignty resides in each individual person.
And this is the critical paradigm shift in their theory. If you are a singular people, you are a sovereign.
Okay.
The defining characteristic of a sovereign is that they are not accountable to a higher earthly authority.
Because they are the top of the chain.
Right. Therefore, in a republic, when the group gathers, debates, and votes on a rule, that majority decision is technically only advisory.
Wait, advisory?
Yes.
You mean Congress passes a law, the president signs it,
Right.
and as an individual sovereign, I can just look at it and say, thanks for the suggestion, guys, but I'm going to pass.
According to this specific legal framework, yes.
That is wild.
The logic is rigid, though. If a rule created by a group became mandatory against a sovereign's will, that individual would immediately cease to be sovereign.
Because someone else is dictating terms to them.
Exactly. They would become a subject to a higher authority, which is the group.
The moment the 51% can force the 49% to do something, you've reverted to a democracy.
Precisely. In a true republic, as defined by these texts, the only inherent limitation placed on a sovereign individual is derived from the common law.
Which is what?
A sovereign cannot injure another sovereign and cannot damage their property.
Okay, so basic do no harm.
Right. As long as you cause no harm to another, the group's legislative rules are merely suggestions. You are totally free to govern yourself.
To explain how this dynamic actually operates in real life, the sources use this really compelling hypothetical scenario.
The bookstore one.
Yeah, the owner versus the janitor analogy. It's so good.
Walk us through it.
Okay, so imagine a guy who works as a janitor in this massive, sprawling, highly successful bookstore. He's there every single day, pushing a broom, taking out the recycling, wearing the little company polo shirt.
Just a normal employee.
Right. But if you watch closely, you notice something really strange. The store manager, the regional directors, the shift supervisors, they all tiptoe around him.
They treat him differently.
They treat him with immense deference. They don't write him up if he takes a long lunch. They don't yell at him if he misses a spot.
And why is that?
Because this janitor is secretly the owner of the entire bookstore franchise.
The whole thing.
He founded the company, he holds all the equity, but he just got bored in retirement and decided he wanted to sweep floors for a few hours a day to stay active.
It's just a brilliant visualization of dual capacity.
Exactly. On paper, in the exact moment he is holding the broom, he has a boss, he has a manager.
Sure.
But because his underlying status is the owner, he can step out of his janitor role at any given second, strip off the polo shirt, and literally fire the manager.
Because the manager only has authority over the role of the janitor, not the man who owns the building.
Right. The manager can't tell the owner what to do.
So the sources use this narrative to explain the listener's potential status under the law.
How so?
In a republic, retaining your status as one of the sovereign people is exactly like being the bookstore owner.
You created the structure.
You own the building. However, choosing to operate as a 14th Amendment citizen in a democracy, which the sources argue is the system the government currently pushes absolutely everyone into, is like voluntarily putting on the janitor's uniform.
You are stepping into the subordinate role.
Yes.
You are voluntarily subjecting yourself to the manager's rules. You are agreeing to be ordered around, to have to ask permission for things, to get licenses just to go about your day.
You are. But the vital protective element of the theory is that because you are inherently the owner, because you were born a sovereign people, you always possess the latent power to take off the uniform.
You can just quit being the janitor.
You can step back into your ownership role and declare, I am no longer operating under the jurisdiction of the manager. I am operating as the owner.
And I guess that explains why, when you look at the government's own internal rule book, which brings us to this massive piece of evidence in the sources, Senate Document 9916.
Right.
They specifically categorize the Bill of Rights completely differently depending on whether you're wearing the janitor uniform or the owner's suit.
Senate Document 9916 is arguably the most concrete and frankly startling piece of evidence provided in the materials.
It is wild. And for context, for you listening, this is not a fringe pamphlet printed in somebody's basement.
No, not at all. It is a nearly 3,000-page, professionally bound book. The formal title is The Constitution of the United States of America, Analysis and Interpretation.
It's a brick. It's a literal brick of a book.
It is. And according to the congressional lectures we reviewed, a physical copy of this immense volume is issued to every single U.S. senator, every representative, and the vice president.
So it's official.
It serves as the federal government's own internal definitive manual on how the Supreme Court interprets the Constitution.
And the sources point us to a very specific, deeply buried section of this 3,000-page brick.
Yes.
We are looking at pages 956 and 957, specifically footnote number 12.
Footnote 12.
And the way this footnote explicitly categorizes the Bill of Rights creates a stark, totally undeniable dividing line based entirely on that citizen versus people distinction we've been unpacking.
Right. The footnote meticulously lists which specific constitutional protections are actually available to U.S. citizens and, shockingly, which are not.
Right, and the terminology is crucial here, too.
Extremely crucial.
The sources highlight that the government document doesn't say citizens possess natural rights. It says citizens possess civil privileges, or civil rights.
And as we discussed earlier, a civil privilege is an allowance granted by the state.
Which the state theoretically has the power to regulate or revoke.
Exactly. So the text of footnote 12 details the privileges that the federal government has decided to selectively incorporate and make available to U.S. citizens.
What's on that list?
Well, it includes portions of the First Amendment, such as freedom of speech, press, and religion. It includes Fourth Amendment protections against unreasonable search and seizure, and Fifth Amendment protections against double jeopardy and self-incrimination.
Okay, so if you are operating as a citizen wearing the janitor uniform, you get free speech and you get the right to remain silent.
Right.
That sounds completely normal. That aligns with every high school civics class in the country.
It does.
But then you get to the second half of the footnote. The government explicitly lists the amendments that are not available to U.S. citizens.
And this is where the theoretical framework solidifies into a documented legal reality.
It gets so crazy here.
According to the government's own analysis in footnote 12, the privileges not available to U.S. citizens include the Second Amendment.
The right to keep and bear arms.
Yes. It also excludes the Fifth Amendment right to a grand jury indictment and the Seventh Amendment right to a civil jury trial.
I really need to pause and make sure the weight of that lands for everyone listening.
It's heavy.
The source material is pointing directly at the Senate's own internal rulebook, which states in black and white that a U.S. citizen does not possess the Second Amendment right to bear arms.
It is explicitly listed as not available.
How is that mechanically possible? If the Second Amendment is in the Bill of Rights, how can a citizen just not have it?
The sources explain the mechanics of this by looking at the heading of the section where this footnote is actually located.
Okay, what's the heading?
The heading in the Senate document is titled Amendments Restricting Federal Power.
Restricting power doesn't say granting rights.
Exactly. The foundational legal argument here is that the Bill of Rights was never designed nor intended to give rights to the people.
Because they already had them.
Right. The sovereign people, as the creators of the government, already possessed all their inherent rights. You cannot be granted something you already own.
That makes sense.
So instead, the Bill of Rights operates as a list of strict negative limitations placed on the newly created federal government.
It is a leash.
It is a leash. It tells the government what it absolutely cannot do to the sovereign people.
It's a thou shalt not list for the government, not a permission slip for the individual.
Precisely. However, the mechanical shift happens when you change your status.
When you put on the uniform.
Right. If you step down from the supreme status of the sovereign people and legally classify yourself as a 14th Amendment citizen, meaning you are now a creation of the government subject to its jurisdiction, those absolute restrictions on the government no longer apply to you in the same way.
Because you aren't the creator anymore.
The government possesses the inherent authority to regulate its own creations.
The manager can tell the janitor what to do.
Exactly. Therefore, as a citizen, you do not get the absolute sweeping protection of the Bill of Rights. You only receive the specific, limited civil privileges that the government selectively decides to incorporate and hand down to you.
And according to footnote 12, they have simply chosen not to hand down the privilege of bearing arms or a grand jury to the citizen class.
That is what the document says.
So if I am operating as a sovereign people, my right to bear arms is absolute because the government is legally restricted from infringing on it.
Correct.
But if I am operating as a citizen, I only have a privilege, and the government can say, actually, we aren't granting you that privilege today.
That is the exact mechanical difference the sources outline.
But, I mean, this brings up a massive question.
Yeah.
If this is true, if identifying as a citizen means you surrender absolute rights for conditional privileges, and you don't even get all of them, why is this entirely absent from the educational system?
It's a fair question.
Why isn't the distinction between people and citizen day one of every high school government class in America?
Well, the lectures in our source material tackle this question head on. They argue that the true historical definition of the word civics is the study of the natural rights and duties of the sovereign individual.
But when I took civics, we just learned how a bill becomes a law and like the three branches of government.
Right, the mechanics.
We learned the mechanics of the system, not the rights of the individual above the system.
And the sources argue that this shift is entirely intentional.
Really?
Yes. True civics, they claim, is no longer heavily taught precisely because the modern administrative state relies entirely on the population, assuming they are citizens subject to jurisdiction.
They need you to think you're the janitor.
The system requires millions of janitors to keep the machinery running. If everyone woke up tomorrow, understood the grammatical difference in the preamble, and realized they were actually the bookstore owners, the managers would instantly lose all regulatory control.
It's an assertion that the curriculum is designed by omission to maintain a massive illusion of subordination.
The heavy accusation.
That is a wild, heavy accusation against the educational and legal institutions.
It is a sweeping, systemic claim.
But let me push back here for a second, because I'm putting myself in the shoes of someone listening who is trying to apply this to their actual life.
Sure, let's ground it.
I'm looking at my wallet right now. I have a state-issued driver's license. I have a Social Security card. I have a U.S. passport. I file my taxes every year using government forms.
Right, all the standard paperwork.
If the government requires me to operate as a citizen to get all these things, haven't I already signed on the dotted line?
You mean, did you already waive your sovereignty?
Yeah. By participating in all these administrative systems, haven't I essentially signed away my sovereign rights and permanently agreed to be a subject citizen?
Yeah.
Is there any coming back from the paperwork?
It is the most practical logistical hurdle the theory faces, honestly. If commerce and modern life require you to interact with the state, do you forfeit your sovereignty by doing so?
Right. Do you?
To answer this, the legal experts in these texts introduce a very specific and highly relevant piece of Supreme Court precedent.
Which case?
The case of Marion v. Jicarilla Apache Tribe.
And this case is presented as the ultimate legal shield, right?
It really is.
It's the mechanism for how you can supposedly exist in the modern world, sign contracts, and engage in commerce without losing your underlying sovereign status.
It is the linchpin of the defense. So the case centers around the Jicarilla Apache tribe. Like many recognized Native American tribes, the Jicarilla hold a unique legal status as a sovereign nation existing within the borders of the United States.
Okay.
They have their own governance, their own laws, their own sovereignty.
Right. They are a sovereign entity. So what actually happened in the case?
Well, the tribe decided they wanted to monetize resources on their land, so they entered into a standard private commercial contract with an outside, non-tribal corporation to mine valuable minerals on the reservation.
Just a basic business deal.
Completely standard. The written contract explicitly laid out the terms of the lease, the specific equipment to be used, and exactly how the monetary profits from the extracted minerals would be split between the tribal government and the mining corporation.
It sounds like a totally normal corporate lease agreement. Two parties sign a paper, they agree to the terms.
It was, and it was executed flawlessly at first. Operations began, minerals were extracted, and profits were split precisely according to the terms of the contract.
Okay, so where's the conflict?
Sometime later, the tribal council convened a meeting and passed a new ordinance. This ordinance unilaterally imposed a new extraction tax on the mining corporation for every single ton of minerals taken off the reservation.
Oh, wow. I can see exactly where this is going.
Yeah.
The mining corporation must have lost their minds.
They absolutely did. From their perspective, this was a massive breach of faith. The corporation immediately sued the tribe, and the legal battle escalated all the way to the United States Supreme Court.
Because the corporation's argument, and I mean, it makes total logical sense in the business world, was basically, wait a minute, we have a legally binding commercial contract.
Right. We signed a deal.
We negotiated and agreed on the profit split in writing. You can't just suddenly act like a government and impose a new tax on us out of nowhere. When you sign this commercial contract, you step down from your pedestal as a sovereign government and became a mere commercial partner. You are bound by the four corners of this piece of paper.
It is a perfectly sound argument in the realm of private contract law. You sign a deal, you are bound by the deal. You cannot retroactively change the rules of engagement just because you feel like it.
Right.
The corporation argued that by engaging in a commercial contract, the tribe had effectively waived its sovereign immunity and authority regarding this specific mining operation.
But what did the Supreme Court actually say?
The Supreme Court ruled in favor of the Jicarilla Apache tribe. They allowed the sovereign to keep the tax.
Wait, they let them unilaterally change the financial terms of a signed contract?
They did.
How does the court justify that?
The reasoning the court provided is exactly what the source materials use to validate individual sovereignty today. I want to read the crucial takeaway from the court's ruling as it is cited in the lectures.
Go ahead.
The Supreme Court stated, "It is one thing to find that the tribe has agreed to sell the right to use the land and take valuable minerals from it, and quite another to find that the tribe has abandoned its sovereign powers simply because it has not expressly reserved them through a contract."
Let me digest that.
Yeah.
Simply because it has not expressly reserved them.
Right.
Meaning, just because they didn't write, P.S., we are still sovereign at the bottom of the contract, doesn't mean they lose the sovereignty.
Exactly. The court elaborated further, stating that to presume a sovereign forever waives its inherent powers simply by entering into a commercial agreement or by remaining silent about those powers during a transaction turns the concept of sovereignty on its head.
Turns the concept of sovereignty on its head. Okay, so what the Supreme Court is establishing is a rule of non-waiver. The sovereign entity does not lose its crown just because it signs a piece of paper to do some business in the commercial realm.
And the source material takes this macro ruling about a tribal nation and applies a brilliant, simple analogy to bring it down to the micro level of the individual sovereign.
Oh, the pencil analogy.
Yes, the pencil analogy.
Right. I love this one because it makes the legal jargon so accessible. It goes like this. Imagine you walk into a convenience store. You pick up a pencil, you hand the cashier $1, and they hand you the pencil and a receipt.
Simple enough.
In that moment, you have just entered into and executed a commercial contract. It was an acceptance, and a legal exchange of consideration.
A legally binding, flawless commercial exchange.
But does the fact that you engaged in that commerce, that you executed that contract with the store, mean that the owner of the convenience store now has the legal authority to tell you what time you have to go to bed tonight?
Of course not.
Or does it mean the store owner can dictate how fast you're allowed to drive your car on the way home?
Obviously not.
Of course not, because it is a limited contract. The agreement only applies to the specific transaction of the pencil.
Right.
Engaging in that one piece of commerce doesn't overwrite your entire existence or surrender your autonomy to the store owner.
Now, the sources apply that exact logic, backed by the Hickorilla principle, directly to the individual interacting with the modern administrative state.
So licenses and passports.
Exactly. Applying for a U.S. passport, registering to vote, filing a tax return, or signing an application for a state driver's license, these actions are viewed by this legal theory not as permanent surrenders of rights, but as limited commercial contracts.
Just like buying the pencil.
Yeah.
Or leasing the mining rights.
Exactly.
Yeah.
Under this framework, participating in these government systems or holding these state-issued documents does not mean you have permanently, universally waived your overarching inherent sovereignty as one of the people.
So, mechanically, how does the individual manage both roles? Because I still have to show my driver's license if I get pulled over.
The sources argue you operate in a dual capacity, much like the bookstore owner sweeping the floors.
The janitor uniform.
Right. You can act in the capacity of a citizen for specific contracted purposes, such as operating a motor vehicle on a public state-funded highway, or traveling internationally under the protection of a state passport.
In those specific moments, you put on the uniform.
Yes, and you abide by the manager's rules regarding that specific activity, but you remain a sovereign for all other aspects of your life.
Because, tying it back to the Supreme Court's exact words, to presume you waived your overarching sovereignty just by signing a contract for a driver's license turns the concept of sovereignty on its head.
The legal burden of proof shifts entirely. The government cannot assume you surrendered your supreme status through silence or basic commercial participation.
It has to be explicit.
Under the Hickorilla precedent, sovereignty must be expressly, intentionally, and knowingly surrendered. If you haven't signed a document that explicitly states, "I hereby forever surrender my innate status as one of the sovereign people to become a permanent subject of the state," then you retain it.
Wow.
You can put the janitor uniform on to sweep a specific aisle, but you never stop being the owner of the building.
Man. Okay, let's take a breath and zoom out because we have covered immense, intellectually demanding ground today, navigating a theory that completely reimagines the foundation of American life.
It is a dizzying amount of legal, historical, and grammatical interpretation to process in one sitting.
It really is. We started by looking at the sheer grammatical power of being a singular people, how an 1828 dictionary definition can theoretically define you as an individual creator rather than a collective subject.
Right.
We looked at the profound inversion of power contained in the conditional comma of the 14th Amendment, creating a class of citizens subject to jurisdiction.
We examine the structural mechanical difference between a democracy, where the group holds absolute sovereign power over the minority, and a republic, where sovereignty rests safely within each individual, rendering group mandates merely advisory.
The owner versus the janitor.
Exactly.
We dove into the shockingly specific text of footnote 12 in Senate Document 9916, revealing the government's own internal view that citizens operate on revocable civil privileges, lacking absolute rights to bear arms or face a grand jury, while the sovereign people retain absolute natural rights because the Bill of Rights restricts the government, not them.
And finally, we explored the protective precedent of the Hickorella Apache case.
Proving that in this framework, signing a limited commercial contract for a driver's license or a passport doesn't mean you've surrendered your crown through silence.
Right.
So what does this all mean for you listening right now? Why does parsing 19th century dictionaries and obscure Senate footnotes matter? We stated at the beginning that this is a highly unorthodox interpretation of the law.
We did.
But regardless of its current judicial viability, it serves as a truly fascinating paradigm-shifting lens through which to view your own relationship with authority.
It forces you to look at the contracts you sign, the licenses you apply for, and the inherent freedoms you possess.
And ask a fundamental question about the architecture of power. Who is really in charge?
It demands a rigorous reevaluation of our most basic assumptions about the state. And I want to leave you with a final thought to mull over as you go about your day.
What's that?
A thought that builds directly on the Hickorella principle of non-waiver we just discussed. Under that Supreme Court precedent, sovereignty cannot be waived by silence. It must be expressly, knowingly surrendered.
Right.
So ask yourself, did you ever sign a document intentionally, knowingly, and voluntarily giving up your status as one of the sovereign people?
Did a government official ever sit you down and explicitly explain that you were trading your absolute natural rights for conditional civil privileges?
Or were you simply classified as a citizen at birth, given a social security number, and handed the janitor's broom without ever once being told that you owned the building?